Hello, viewers. This is Major General Neelendra Kumar for the YouTube channel Lex Consilium Foundation and the playlist Nurturing Smart Teachers. In this session, we are in conversation with Advocate Anil Malhotra, a world known authority on international family law based in Chandigarh. He has over almost 4 decades experience in law practice, appeared before different jurisdictions, courts, and tribunals. In this video, we will talk about some of the leading decisions by the Supreme Court of India that impact practice in international family law. And my first question to you, Anilji, is with regard to the waiting period, what is the significance of the decision in the matter of Amandeep Singh versus Harveen Kaur? That's a 2017 reported case.
The decision of the Supreme Court of 2017 here has settled the position of law insofar the waiting period of filing and thereafter resolving the waiting in mutual consent divorces is concerned. Under Section 13B of the Hindu Marriage Act, we have a mutual consent divorce. The provision says that only if the parties have been living apart for 1 year, have not been able to stay together, and do not intend to stay together, that a matrimonial petition for divorce by mutual consent can be entertained. The second provision in 13B is that after filing the petition, the matter has to be adjourned for a period of minimum of 6 months as a cooling off period. Thereafter, this divorce is confirmed whether to be granted or not to be granted if parties' consent still subsists. Now, what has the decision done? It has crystallized the law on the point by saying that it is not necessary that the parties should have been living apart for a year. It is also not necessary for them to wait for 6 months. So, the discretion which the Supreme Court has interpreted goes to the family court. Now, in the family court, if in its discretion or in its wisdom, things fit and appropriate, so to say, then the Supreme Court says that the family court can exercise this discretion after hearing both the parties and after the court feels upon such an making such an inquiry that the parties cannot live together. I just want to bring in this for a wider interpretation to understand it better. Suppose parties are living abroad. They have already dissolved the marriage abroad by irretrievable breakdown. They are only looking for a stamp of recognition in India. Now, for in such a situation, to say that you'll be living apart for 1 year, that you wait for 6 months, sounds a little way out. So, the Supreme Court, in its wisdom, has given the discretion to the family court judge to exercise it whenever the court deems fit, so to say. So, this crystallization of interpretation by giving the interpretation liberally and leaving it to the discretion of the family court has made things simpler, easier, and under Article 141, of course, it's the law laid out.
Wonderful. So that settles it, and it gives some elbow space to the courts also. We move on to the case of Shilpa Salesh. Now, this decision, which falls in the area of dissolution of marriage, the Supreme Court dealt with its exclusive powers under Article 142 of the Indian Constitution on the with a view to do complete justice. And this Shilpa's matter was on the grounds of irretrievable breakdown of marriage. Would you like to explain to the viewers as to the significance of this decision? I'm talking
Uh,
about Shilpa Shailesh versus Varun Srinivasan.
just for a background understanding, We have a fault based divorce structure under the Hindu Marriage Act and the Civil Marriage Act. We also, as we have just talked, we have a mutual consent option. Now, irretrievable breakdown as a ground for divorce is a concept we do not have under the Hindu Marriage Act. Our marriages are a sacrament. Unlike the West, where marriage is a contract, we don't dissolve marriage for the asking. We try to save the marriage. We try to keep the marriage intact. But ever since this law was enacted, from 1955 to 2025, things have changed. Society has moved on. Irretrievable breakdown divorce decrees are exported or imported to India, from India, and they are put before the courts. Parties are no longer able to live together. Parties want to settle. Or let us say parties have been fighting for 15 to 20 to 25 years. Steam has run out, money has run out, children have grown big, parties have very bitter animosity. In such a circumstance, Supreme Court adorns the family court jurisdiction, but not under the Family Courts Act or the personal laws. Supreme Court uses its extraordinary powers under Article 142 to do quote unquote complete justice in the facts and circumstances of given case. Now, this power under 142 is an extraordinary power reserved to the Supreme Court only, and it extends to all matters. The question is, it is being used to bury the hatchet. And now, after 25 years, in Shilpa Shailesh, a five-judge constitution bench in 2023 has set the matter to rest by going into different benches, decisions of the Supreme Court. Supreme Court is the court of record. It can review its own decisions. And they have said it is our privilege, it is our prerogative to dissolve a marriage under 142 if we want to, so fit, think fit. So 5 crores, 6 crores, 10 crores. Today only I was reading in the newspaper, the Supreme Court settled the matter. The woman wanted 12 crores and a BMW. So they said a 4 crore flat in Mumbai is enough. So this is how matter is sorted out. You don't get a meal ticket for life. You get alimony. You get a place to stay. 20 cases filed by both sides on dowry, desertion, cruelty, domestic violence, injunction, custody, all are resolved. Settlement is drawn up. Package is made. And there you are. But the question which begs the answer is Supreme Court as a constitutional court is now taking on the role of settling marriages, which is the job which the parliament should address by bringing in a irretrievable breakdown head with safeguards in the statute. 142 is a weapon which is only with the Supreme Court, not with the High Court, not with the Family Court. So I think the Supreme Court of India is obviously meant for better things and more important things. The Parliament ought to look at this seriously. The Supreme Court has taken upon itself by a five-judge constitution bench because they want to put an end to misery of people. They want to end anguish, pain, suffering, children's parental alienation, and so on and so forth. So it's a weapon devised at the time of war only to be taken out by the generals. The soldiers carry on with the personal loss.
Thank you. You brought it out quite clearly that the ambiguity and the confusion that was there due to the different benches at different times coming up with decisions, and then existed a need for clarity and a singular view, and that came up with this Shilpa Salesh decision of the five judges bench. And I must tell you, viewers who are all students of international family law, that in his book, uh, Anil Malhotra has very clearly discussed the issues relating to impacting international family law, and all decisions The latest ones by different courts and also of the Supreme Court have been compiled. You will find them in this book, and it would help you in gaining clear understanding of the subject. With this, I move to the third case, and that related to the best interest of the child. And I'm referring to Lahari Sakhamuri's case of the Supreme Court, and also in the matter of Jasmeet Kaur versus Estate NCT of Delhi. Both the cases are reported, they are of 2019. I would like Anil you to please explain as to when was the law laid down and how are the two cases to be read together to arrive at the correct understanding with regard to the notion of best interest of the child.
Thank you, sir. First of all, for the purposes of record, the co-author of the book, Anil Malhotra, a young LLM SWAS graduate from on a Felix scholarship, has contributed immensely to the research, to the phrasing of the book, settlement of paras, and it is he who, as a younger, brighter, sharper mind, gave me so much clarity on so many issues which
Yes,
you are
this is
raising.
to be noted. Yes.
Thank you, sir. Now, coming to the area of child custody. Now, insofar issues relating to custody, guardianship are concerned, we have an archaic law, the Guardian and Wards Act of 1890, which the Britishers made for us, which instead of putting in a museum, exists on the statute book and is the only armory weapon which a family court judge can use. He can't travel beyond it because it is what he is supposed to read as a soldier and use before him whenever there is a case before. So this Guardian and Wards Act talks about singular custody, exclusive parenting, singular guardianship, and it is obviously absolutely out of place in today's times. Our personal laws, let us say Hindu Minority and Guardianship Act, don't stand on their legs. They say we are a subordinate legislation. Sadly, in 1956 also, we thought the British were going to give us the legs, and the legs are in the Guardian and Wards Act. So sad. You can't take custody under the Hindu Minority and Guardianship Act. You have to fall back because there is no way you can go to a court through the Hindu Minority and Guardianship Act. So a parent who removes a child, say in India or from abroad, goes to a family court, or if there is no family court, to the senior judge civil division, and says, "Please give me sole custody. Please give me sole guardianship. I am a better father. I am a better parent. The other parent is no good." Now, this entire exercise is a misplaced war, an ugly battle, and nobody wants to talk about the child. The custody petition is only meant to settle scores with each other, fling mud, and try to prove who am I superior, who is superior. And in the bargain, the child becomes a table or a chair for the highest bidder to take away. So whoever wins, I think, loses because the child is lost. Now, in this mess or muck, starting from Surinder Kaur's judgment by Justice Chandrachud, not the current one, the previous YV Chandrachud, in Surinder Kaur in 1984, it talked of the best interest and welfare of the child and to be determined by the jurisdiction of closest contact. That concept from 1984 to Nityanand Raghavan has been tinkered around at different points of time with different interpretations and different views by the Supreme Court. Now, added to this is India signing the United Nations Convention on the Rights of the Child and incorporating it in the Juvenile Justice, Care and Protection of Children Act and in Section 2(9) of the JJ Act defining the best interest of the child. So we have now started following what is the definition of the best interest of the child in the decisions which our courts render. And it's a very beautiful definition. No other country in the world has such a good definition. Let me admit it. I was part of the Bindal committee where we were looking at developing a law on child removal. Six judges and six government officers. I was the only lawyer. And we used that definition, and we even suggested a bill to the government defining interparental removal or wrongful retention of a child. The bill was made since 2019. It is in slumber on the archives and shelves with the law commission reports. Nothing is being done. But then the vibrancy of the Supreme Court is moving. A three-judge bench. First came Justice Lacour in his brilliant judgment to start with. Then came Nityanand Raghavan, a three-judges bench headed by Justice Deepak Mishra. Then came Justice Khanwelkar in Lahari Sakhamuri. The three-judge bench said, following the tender years rule, the small child up to 7 years of age, I don't know where they got 7 from, should be with the mother. Best interest is with her.
Uh,
Now,
yes, please continue.
but then came Justice Khanwelkar in Lahari Sakhamuri. He says, let us reconcile the best interest of the child definition with the definition or the concept of tender years rule. Under Section 6 of the Hindu Minority and Guardianship Act, it says that the custody of a child, the natural guardian of a child shall be the father and after the mother, and ordinarily speaking, the custody of a child less than 5 years of age shall be with the mother. But then the myth in Lahari Sakhamuri was demolished. Justice Khanwelkar brilliantly said that if you read 2(9) with tender years rule, it's immaterial how old is a child. Less than 5 years can be with father, more than 5 years can be with mother. The question is best interest. In the Guardian and Wards Act, in the Family Courts Act, it's openly said determination of the best interest is what you have to do. Now, in this, so to say, balancing and into vibrancy of interpretation, I think our Supreme Court scores in the world. I was part of a international meet in Washington in April, representing India with closed door meeting of 100 judges and top government officials. I was the only country which is a non-signatory. And everybody said we have a rule, we follow the convention, we adopt. I said we interpret the convention, even though we are not a signatory, and we define the best interest under the UNCRC, and our courts decide. And our courts are not stuck, stagnant, or stigmatic with a view or opinion. We change. When the time comes, things have to evolve, we change. So this is the walkaway from Nityanand Raghavan and Lahari Sakhamuri. To start with, Justice Lacour's judgment was also brilliant. He said theory of first strike. Whichever jurisdiction takes control first has the reins, but this concept has been watered down. Best interest of the child and the jurisdiction of closest contact still sways. But there is still a lot of lack of understanding on the subject. Because in the lack of a statute, for the lack of a law, interpretation vary as thinking varies. And that brings me down to Jasmeet Kaur versus Navdeep Singh, in which I was a counsel for 3 years. The one child was born in India, one child was brought from the US, overstayed, foreign court order was brought for implementation, mother went to family court. It was a crisscross. In the habeas corpus, Justice Vipin Sanghi, in a brilliant judgment authored, said, I am sending the children back, and I was asked to get the conditions laid down for the protection of the spouse and the children, made a part of the US court order, meaning I had to mirror the order. It was a tough task. We did it. I brought a mirror order. The matter was still challenged. The mother lost in the family court and the High Court. Matter came to Supreme Court. And Supreme Court said You have these protections, go back. Another mirror order was sought, they said no. So, this coining of a new jurisprudence was a step forward, but it fell back very badly in Perimon Consagra, where a man took away the child after 12 years to Kenya and refused to bring the child back. So there is a flashback also, but we have to put our country in a larger picture, and we have to have some method of devising return of children. Till then, I think Justice Lacour, Justice Mishra's judgment, and then Justice Khanwilkar's judgment, and to start with Justice Chandrachud's judgment in 1984, are brilliant minds which are giving different vibrant interpretations. So this is not a stagnant proposition. Thanks to the dynamism of our thought process in the Supreme Court and the High Courts, we evolve principles, but the fulcrum is the best interest of the child. That's what we are all about.
Thanks, Anil. You have spoken brilliantly on the best interest of the child. But I would like, once again, though you have already mentioned to Nitya Anand Raghavan's case, but with regard to the custody of a girl child, would you like to add anything extra in having regard to Nitya Anand's case?
Uh, Sir, I think in today's times, when we have 34 million people living outside India, most European jurisdictions have a population of 11, 12 million. We are 1.4 billion. I think men and women are at par in terms of thoughts, in terms of earning, in terms of economic independence, in terms of development, and we are changing over a period of time. Abroad, you have sit-home fathers, you have working mothers, you have divided parents sharing custody even if they are remarried. You have to think in a bigger way. Don't give custody to one parent. Give joint custody if you can do it. If the parents live in the same city or live within India, give joint custody. Let them make joint decisions. Let them have shared parenting. Law Commission report number 257 has suggested all these things. Put joint custody, put shared parenting, put joint decisions. Have mediation. And I think we should now step in into arbitration in family law. Why go to courts? Have an arbitration decision. Take it to court and get a seal of approval. You have to understand that custody, control, and a right of superiority by your superior parenting is not the best interest of the child. You may be very good parents, you may be bad husband and wives. What does the child want? He wants a family. And what is family? Father, F, A, and M, mother. I love you. So I think instead, sir, with due apologies, instead of getting into this gender stereotyping, you have to think out of the box. We can't have ideology. You cannot superimpose your values and my values on a generation which is talking of artificial intelligence, which is talking of living in outer space, which is talking of homes in two jurisdictions, which is also drafting at pre-nuptial agreements before they get married without telling their parents. So you have to think out of the box, but at the same time, make them equal, but leave it to the court, as the Supreme Court has done in the matter of divorce. There is ample discretion under the Guardian of Rights and the Family Courts Act for the best interest in determination of the child. Leave it to the judge. If a girl is going through sensitive years, she needs her mother more, definitely. Give her contact, more contact, access. See, in India, the problem is whoever has the custody will badger and browbeat and make mincemeat out of the other parent who is the non custodial parent. You have people going to Supreme Court and time saying my wife doesn't allow me access. I'm going on Friday. So we have to stop treating the child like a chattel. We have to stop treating the child as an object to. The child is not a trophy. Female trophy is to be given to mother, male trophy is to be given to the father. I most respectfully disagree with gender stereotyping.
Thank you very much. Stay with us. This conversation will continue.
Thank you, sir.